A federal appeals court has just ruled that California's long-standing ban on openly carrying firearms is unconstitutional, and this decision represents one of the most significant developments in California gun law in years. But before anyone assumes this ruling suddenly legalizes open carry statewide, it's important to understand exactly what the court did, what it did not do, and why this decision matters far beyond a single statute or a single state. The case centered on California's near-total prohibition on openly carrying firearms in public. For decades, California has effectively banned open carry in most populated areas, while simultaneously maintaining a restrictive concealed carry permitting system. For years, the state relied on the argument that even if concealed carry permits were difficult to obtain, citizens theoretically retained the option to carry firearms openly. In practice, however, that option was largely unavailable. The appeals court rejected that framework, applying the Supreme Court's Second Amendment test established in New York State Rifle and Pistol Association versus Bruen. The court held that California failed to demonstrate a historical tradition that would justify a broad prohibition on open carry. Under Bruen, the government must show that modern firearm regulations are consistent with the nation's historical tradition of firearm regulation, particularly during the founding era and the period surrounding the adoption of the 14th Amendment. According to the court, California could not meet that burden. The state argued that historical laws restricting the manner of carry supported its position, but the court found those examples insufficient. Instead, the court concluded that open carry was widely permitted throughout much of American history and that outright bans on open carry are a modern invention rather than a historically grounded restriction. This ruling matters because open carry has always played a critical role in how courts analyze public carry laws. Historically, states were often permitted to regulate the manner of carry, but not to prohibit all forms of public carry entirely. If concealed carry was restricted, open carry remained available. If open carry was restricted, concealed carry remained available. What courts consistently rejected were systems that eliminated both options at once. California's system effectively did just that. Open carry was prohibited almost everywhere, while concealed carry permits were issued at the discretion of local authorities and often denied without objective standards. Even after Bruen forced California to adopt a shall-issue permitting system, the state continued to rely on open carry restrictions as part of its overall framework. The appeals court's decision directly undermines that structure. If open carry cannot be broadly banned, and concealed carry must be issued under objective criteria, California's ability to restrict public carry becomes significantly narrower. This doesn't mean the state cannot regulate carry at all, but it does mean those regulations must be tightly tied to historical precedent rather than modern policy preferences. It is critical to emphasize what this ruling does not do. It does not automatically legalize open carry statewide. It does not immediately invalidate every statute related to public carry, and it does not prevent California from seeking further review, either through an en banc rehearing or by petitioning the Supreme Court. In practical terms, the ruling places California at a crossroads. The state can attempt to defend its laws through further appeals. It can attempt to revise its statutes to comply with the court's interpretation of Bruen, or it can attempt some combination of both. What it cannot do, at least under this ruling, is continue to rely on a blanket prohibition on open carry without historical justification. The broader implications of this decision extend well beyond California. Other states have relied on similar arguments to defend restrictive carry regimes, particularly in jurisdictions where officials have attempted to limit both open and concealed carry simultaneously. This ruling provides a roadmap for challenging those systems and reinforces the principle that the Second Amendment protects some meaningful ability to bear arms in public. The decision also reflects a broader shift in how lower courts are being forced to approach Second Amendment cases. Prior to Bruen, courts often relied on interest-balancing tests that weighed public safety concerns against individual rights. Bruen rejected that approach, replacing it with a history and tradition test that leaves little room for judicial discretion based on modern policy considerations. Many lower courts have struggled to apply that test consistently. Some have attempted to narrow Bruen's scope or delay its impact through procedural rulings. Others have engaged in selective historical analysis to uphold long-standing regulations. This decision signals that appellate courts are increasingly unwilling to tolerate those approaches, at least when the historical record does not support the regulation at issue. For gun owners and legal observers, the key takeaway is not that open carry is suddenly legal everywhere in California, but that the legal foundation for California's carry restrictions has been weakened. Future challenges will likely build on this ruling, particularly as plaintiffs argue that states cannot eliminate public carry options entirely without running afoul of the Second Amendment. It is also worth noting that this ruling arrives at a time when the Supreme Court has shown renewed interest in enforcing its Second Amendment precedents. Over the past several years, the court has repeatedly stepped in to correct lower courts that resisted or misapplied its rulings. While it is impossible to predict whether the Supreme Court will take up this particular case, the broader trend suggests that courts ignoring Bruen do so at increasing risk. From a legal standpoint, this case reinforces several principles that are likely to shape Second Amendment litigation going forward. First, historical evidence matters, and courts are expected to engage with it honestly and thoroughly. Second, states bear the burden of proof when defending modern firearm regulations. And third, regulatory schemes that exist primarily as workarounds to constitutional protections are unlikely to survive sustained scrutiny. California lawmakers now face difficult choices. Attempting to preserve the existing framework through minor adjustments may not be sufficient. Any new regulations will need to be carefully crafted to align with historical analogs, and even then, they may face immediate legal challenges. The era of expansive discretionary carry regimes appears to be coming to an end. For residents of California, the immediate legal landscape remains largely unchanged while the state considers its next steps. Open carry remains restricted under existing statutes, pending further court action. However, the certainty that those restrictions will remain in place indefinitely has been shaken. This ruling introduces real uncertainty into a legal regime that once appeared settled. Nationally, this decision will likely be cited in cases challenging public carry restrictions in other states. Courts examining similar laws will now have to contend with this appellate ruling and its interpretation of historical carry practices. While outcomes may vary depending on jurisdiction, the direction of Second Amendment jurisprudence is becoming increasingly clear. This ruling does not represent the end of the legal battle over public carry, but it does mark an important turning point. It underscores that the Second Amendment is not a second-class right, and that courts are expected to enforce it according to the standards set by the Supreme Court. As these cases continue to move through the courts, the practical scope of the right to bear arms in public will become more clearly defined. Going forward, the focus will be on what California does next, how other states respond, and whether the Supreme Court chooses to weigh in. Each of those developments will shape the future of public carry laws across the country. For now, this decision stands as a clear statement that broad bans on open carry cannot be justified without strong historical support, and that states attempting to restrict public carry must operate within constitutional limits. As this case continues to unfold, the legal landscape will continue to evolve. What is clear is that the question of how, where, and under what conditions firearms may be carried in public is far from settled. This ruling ensures that those questions will be answered through constitutional analysis rather than political convenience, and that alone makes it one of the most important gun law decisions in recent years.